Hi guys, it's Kathy. I got a super annoying pro say from 2023 that you probably forgot about. I have not forgotten about him at all. Here we go.
Yes, Your Honor. I think at this time, Mr. Goheen Ringo would like to address the court and is either requesting in counsel or to move forward pro se.
Unfortunately.
Why?
No, it's great.
Okay. Mr. Goheen Ringo, if you want to address the court, you need to address the court. And you can go ahead and do that.
Yeah, I'd like discovering it. It's my knowledge that in order to have full discovery and access to my case, I would have to represent myself. And I'd like to do that. And I'd like a 2-month continuance so I can gain my medical records about my broken wrist that was broken 2 days prior to this incident on September 20th, 2020. I'd also like to make it on the record that I've asked my attorney to put 3 or 4 different motions in. He has not since he's started representing me in this matter. I'd also like to voice, because no one else has for me, that on August 29th, my attorney, Diane Sweet, that works for Ian Marr, violated my attorney-client privilege in front of an officer, Officer Crane, during transport. He's just the transport officer, but he took it upon himself to go on record and address the court while I was left outside.
Okay. Mr. Goheen Ringo,
I'm putting this on the record.
today is for, if you have a request for new counsel, make that request.
Yeah, so in order for me to get my discovery to myself, I would need to go on pro se from here. Is that correct? Because
well, it's not correct.
Oh, okay.
So I would provide you with a copy of your discovery.
Okay, in the thumb drive of the video.
That is a different question altogether, but
No, it's part of the discovery.
Wait a minute. This isn't for you to argue with your attorney.
I'm not arguing.
Are you making a request for new counsel, or what are you doing?
I want my thumb drive with the video that shows what actually happened that day. So I guess I need to
Stay up here and see.
I mean, I can stay up here and go into his office and watch the video. I've already seen it. But I want a copy of it. I believe I have a right to that. And I'm going to have to spend probably $10,000 out of my pocket for a private attorney that will do what Mr. Marr could have done and what I was requesting to do, to put these very important, vital motions in a timely fashion.
So are you able to hire an attorney who charges $10,000?
I'm going to have some time to do that. Yeah. And I've been working my butt off here and doing all the other stuff that I have to do. I've got 5 children I'm providing for, trying to, 2 elderly parents that I work and caregive for. And, you know, my boss is elderly. I do farm work. That's why I do hard, honest work with my life. And I had to drive up 40 minutes just to get here because I thought it was in person. I want to show a good show to everybody that I'm here to take this seriously as can. I get here and I learn it's a Zoom hearing. So it's okay. I want to see the discovery. I'd like the full, yeah, I will.
All right.
And I'd like a thumb drive so I can go into an attorney's office and say, hey, do I have a case here? I'm sure anybody will see that I do. Thank you, Your Honor. And I'm sorry for anything abrasiveness. I do not mean it. I skipped breakfast to get here. I'm generally kind of stressed out in the mornings anyway. So.
Okay. So in terms of next week's trial, I already indicated we don't have a judge available. Sounds like you're asking for a continuance either way.
Yeah, but I'd like it more than two weeks. The 2 weeks is no wiggle room or breathing room. I work every single day.
Okay. So wait a minute.
Right.
Are you willing to waive your right to a speedy trial?
Yeah, I am. It's important.
So that would mean you'd be tried within 90 days of today's date. Are you willing to do that?
Yes, sir.
All right. I'll accept the
push it out
waiver.
as far as you could. That would be the best, not because I'm trying to dodge this. Look, I keep showing up, but people keep mentioning, oh, there's 9 FTAs.
Mr. Goheen Ringo,
what about the 20 to 30 times I have?
Mr. Goheen Ringo, I need you to stop. You're just
I'm sorry. I'm worked up. I had too much coffee. I'm sorry, Your Honor.
All right, so I'll accept the waiver. We'll set today as our commencement date. I'm looking at a new trial date for the end of speedy trial. I'm looking at January 30.
Everson State, Your Honor.
Does that work for the defense?
So am I pro se? I lost the video feed.
No,
here,
you're not pro se.
Oh, I would like to go pro se today so I can get my full discovery and the thumb drive. Thank you.
Okay, you have access to discovery through your attorney.
I'm not getting anywhere with him. He's arguing every single point that I come up. I'm sorry. I'm gonna have to go pro se on this.
To see it today.
No, I don't want the public defense.
Okay, I need you to close the booth door.
I can do that.
Rude. She was helping you with a solid game plan.
And Your Honor, in regards to his request for new counsel, I can simply assert that I'm not able to file motions that I don't find are based on established case law, court rules. I'm constrained to file motions that I believe have merit. And
my motions do have merit. I don't want this man speaking on my behalf on my case anymore. Please disregard anything he said on the record. Thank you.
Well, I'm not going to disregard what he says any more than I disregard what you say.
Well, he doesn't have my permission anymore to represent me.
I'm disregarding him.
There's a complete
He's the
breakdown.
attorney of record. He has the court's permission to talk.
There's a breakdown in communication, Your Honor.
Okay, we're going to set this over for reassignment 2 weeks. At that time, I will, well, actually, let me see here.
Your Honor, I'm asking you
Stop. I need you to stop.
I have a right to represent myself. And I'm asking
Again,
today.
I'm going to, at this point, I'm just going to mute you, Mr. Gohi Ringo, if you're not going to listen.
I was listening to him. Don't mute him. He makes sense.
Kind of a common theme here. So if you represent yourself, Mr. Gohin Rango, you're going to be held to the same standards as an attorney who's licensed to practice law would be held. Do you understand that?
Yeah.
How far did you go in school?
I had a year of college. I also took 3 years of advanced placement, AP government and politics through Washington State, Evergreen Boys State. And
Have you ever studied law or criminal law, first of all?
no, but I have had 10 years of crash course, I would call it.
And he saw at least 2 episodes of Law and Order, Judge. Duh.
Involvement.
Are you familiar with the rules of evidence?
Somewhat.
What does that mean?
Could you explain to me?
Are you familiar with the rules of evidence or you're not, Mr. Gohin Rango?
What are the rules?
I'm asking you to explain what somewhat means. No, I can't explain anymore. If you don't get that, I don't think you're going to do very well representing yourself.
In rules of evidence, then any evidence that the prosecutor or the state has, I also have access to, and anything that I produce as evidence, witnesses or otherwise that supports my defense, I also have to give access to the state. Is that the rules of evidence?
Those are discovery issues.
Oh, okay.
The rules of evidence deal with what can be presented in court and what cannot be. There may be things that you think can be presented in court that may or may not be able to be presented in court, depending on the rules of evidence and how they apply to whatever it is you think can be admitted.
Mm-hmm.
You understand that if you're convicted of assault in the 3rd degree, harassment with a count 1 alleges assault in the 3rd degree, counts 2 through 5 appear to allege felony harassment. Each of those carries a maximum penalty of 5 years in prison and a $10,000 fine. You understand that?
Yeah. Each of those,
25
you were
years.
talking about the felony harassment?
Yes.
Okay.
Those are the maximum possible penalties. That's not the standard ranges. It's the maximum possible penalties. Do you understand that?
Yeah.
It's a really, as a general proposition, it's a really bad idea for anybody to represent themselves. I would never suggest it, even if you were a criminal defense attorney, I wouldn't suggest it. And most people, in my experience, even lawyers who are charged with crimes, that happens occasionally, do not represent themselves. You understand that?
Yes. It's important to me that I'm able to have a copy of that thumb drive and my evidence so that I can pore over it day and night until I'm able to produce not just my side of the story, but an adequate defense for not just for me, but for my children's sake, so that they know the truth of what happened that night.
Okay, stop for a second. I understand you want the thumb drive. Okay, I get that. Mr. Carlo, do you have any objection to providing a copy, an electronic copy of the video that he's referring to Mr. Goulding Booth?
I do not, Your Honor.
I'm not Golding Booth. I'm Goheen Rengo. Sorry.
I'm sorry.
Yeah.
I apologize.
It's okay. I was celled up with Golding Booth. He's quite the character. I pray for him, believe it or not.
That he is. Okay, so sounds like the state's willing to provide you with a copy of the thumb drive.
Be great.
Is he pro se, Your Honor?
If he's pro se, okay.
I had to be pro se.
Oh,
All right, I think that's an important distinction.
Yeah.
You want it today when we're here?
I'm up here in Longview, so I can pick it up today, Your Honor.
Well, you're not going to get it today.
I doubt you'll get anything today.
Well, I know my attorney has a copy of it.
Okay, we don't need to have discussions about all these things at this point. I'm going to consider your request to go pro se. I want to review Ferretta. I'm not sure that I've really adequately covered the colloquy at this point. So you're ordered to appear in person at the Cowlitz County Jail Courtroom, 10:30, Wednesday, the 22nd of November.
And a docket starts at 9.
The docket starts at 9, but I'm not going to call your case until after 10:30. There are other cases on that day, and this is a special set.
You're too annoying to go first. You have to go last.
We're especially setting this on a docket that we normally don't hear these kinds of motions on. So I want to have basically the end of the docket to deal with this, because it may take a little bit of time.
So when can I get my discovery?
After I've ruled next Wednesday.
So I have no access to that until then.
Well, you can talk to your attorney about discovery between now and then.
Yes, if I could address that, Your Honor, I believe we have a redacted and approved copy of discovery for Mr. Goheen Ringo from previous counsel. I'll look into that. So
from his last
drive up
lawyer.
here isn't completely fruitless. If I do, he could pick up a copy of that, since I'm still, for the time being, an attorney of record, and he does have a right to review his redacted discovery.
All right. That'll conclude the matter.
What time?
Thank you. And what time should I pick that up, Ian?
I'm immediately going to check with staff and make sure we have it. If not, I can call you and let you know an exact time. I think at the latest we could get it to you next week when you're back up here.
You guys have it though, right? I mean,
I need to double check it. I can't say with a certainty. I don't know if Diane Sweet made that request when you were her client.
I'm going to end the session.
He did. He just
So-
ended the session just like he had enough. He was up to here, though. Such a chill judge. Like, factual. This is the courtroom. This is the way it's going to go. If anything else happens, it hits him and it rolls right off of him. He doesn't even listen. So that was back from 2023 from a crime that he committed in 2020 that he might get 25 years in prison for. He wants to go pro se. Okay, sounds right. That checks out. Thank you so much for coming out, guys. I really appreciate it. I hope you guys have a great day. Bye bye.